First of all, on the makeup of the DA's office, different than many of the offices that are involved in the cases cited by both sides, the DAs in San Diego are civil service protected. And that does mean something. And it has meant something historically in San Diego County. In fact, San Diego County is rather notorious for overturning DAs. Indeed, even when they're not overturned, there have been times where the incumbent DAs have been run against and a substantial portion of the deputy district attorneys supported the opponents. And even after that, there was little retaliation, if any, because it would be illegal. But I mean, I've witnessed three elections since I've been a judge, and two when I worked in the office, and I saw what happened. So they have a certain amount of solidarity among themselves, but also are allowed to be individual prosecutors. And because of that, I'm not going to recuse the entire office. There's just, if I needed to, I could order some type of wall erected, but there's no way I would recuse the entire office. The issue of conflict, I think there's just 3 or 4 cases really that matter. You know, Lastra, Eubanks, Choi, Hollywood. And this case is so far away from those type of cases. As we discussed earlier about Lastra, is that, you know, that was almost a contemporaneous fundraising event as the San Luis Obispo DA criticized the closing of a freeway during a demonstration. I think it was Black Lives Matter. Nonetheless, I mean, Summer Stephan, from what I know, and I don't have any evidence, she didn't specifically fundraise off the case that we have at bar. Nor do we have a deputy district attorney or her compromised by sleeping with a witness, by engaging in any unethical behavior that would require discipline. The Eubanks case on fundraising is, you know, that the organization that the district attorney used was actually paying for the prosecution, and then that district attorney made an issuing decision, and obviously they were conflicted over the money that was coming in. It was not a campaign contribution. They paid for the investigation in that case. In any event, I don't believe there's an actual conflict. I don't need to get to the second run because I don't find there's a conflict. That does not mean that's not a triable issue, and I'm not making any preliminary rulings. But I don't find there's an actual conflict, and I'm going to deny the request to recuse the DA's office. We're going to get to the motion to sever, but now I'm going to say some things. And I want everybody to pay careful attention who's litigating this case. I don't care about anybody else. But you brought it up, Mr. Briggs, and I think it's really important. And before I forget it, because I forget things, I want y'all to know what's going to happen here. It looks like we're marching forth to trial. I don't see us getting to trial in February. It sounds like you have the stockload of motions to file, and they're going to take some time to do. Let me just reach you want to be heard on the motion to sever?
Not based on what the coach just said.
Yeah.
I was just going to say my scheduling needs to change, but I still want
on the motion to sever, I'm going to deny it. But with a huge caveat here. We may not have in the court the manpower to try all 4 together. my deputy has informed me, and I've talked to other deputies too, that I may need 5 to 6 deputies to do the trial altogether and for 6 weeks, and we don't have that type of resource here. So I'm going to deny the motion to sever without prejudice, and once we get closer, I'm going to think about if I need to break it apart, just because I don't know how we're going to do them all together. I mean, I've got the courtroom, but I don't know if we have the staff to do it. But listen up. None of you have any idea what I will do at trial, at the end of trial. And as I talk to the defense, I'm going to talk to the prosecution too, okay? But anything I've said, anything I've done, the color of my tie, the type of haircut I have, should not give you any indication of whether or not I will send your clients to prison if they're convicted, right? So best case scenario is I give them a light sentence if they're convicted. Worst case is I hammer them. And you don't know if I'm going to do that or not because I'm going to listen to the evidence. And I can tell you, last couple trials I did, when I listened to the evidence, it was a lot different than what was said to me during readiness. And it had some dramatic effects. To the prosecution, I may hear all this, you may get a conviction, and I may just give probation. I mean, that is a distinct possibility. And I also caution everybody about the environment and the times that we're going to be trying this case in. Right, if we're picking a jury in March, maybe April, I mean, it's going to be at the heat of the political season, and watching how all these fools behaved is a good indicator of what we're going to see with juries and we're going to see with tension outside the courtroom, which is the other reason why I need a lot of security. So I want you guys to really think about offers and possible pleas, because we don't know what's going to happen. We just don't. And, you know, I've had some hung juries on some pretty strong cases lately, and it's shocking to me. But there was no political context. Here there's a political context, and you don't know, you're going to be stuck with who you get in that jury bar, in that panel, and you're not going to know them that well. Here's what I have planned if we keep the case together. Jury selection will take 2 weeks. Each day, I'm going to bring in 50 jurors. I'm going to talk to 200 to start, and then we're going to bring in 50 a day, 25 in the morning, 25 in the afternoon for 4 days. If we have enough after they're hard shipped on the following Monday, then I'll give more voir dire time, and then we'll start challenges. All right? But what I want to do that first week is try and hard ship and get as many jurors who can spend the time, A, and B, who are not going to be politically motivated, right? That's going to be a toughie, right? So I'm saying 200 to start. It may be way more than 200, right? So I'll give you ample voir dire time. I'm going to have some rules about those clients that are represented by 2 attorneys, right? If you're questioning, you do the objection, and nobody else talks. I'm not going to have anarchy. I'll allow everybody to voir dire. But I would seriously consider settling. You just don't know what's going to happen. And I've looked at the videos. I still have to have an open mind, and I do. But there's substantial liability at stake for everybody here, and I hope you all consider that.